Hey, good afternoon, everybody. Thank you for joining us. My name is Neil Kalin, and as I am always joined every month by Michael Simkin, and we're gonna give you a case law update today. So, hi, Michael. How are you?
I'm fine. How are you?
I'm doing great. Um,
A little bit brighter today. I should stand up. Yeah, here you go. And you can see the
yes, yes.
shiny forehead now.
I had one of my colleagues yesterday who was in the car, and I don't know what kind of setting he had on his phone, but we had a nice close up of his nose uh, while he was on the webinar. It was really kind of funny. So that's life. That's life in 2025. It doesn't matter how long we've had to get used to Zoom or Teams or whatever program that you're on. There's always things like that going on. Dogs barking, gardeners blowing, all sorts of stuff. That's life. But we're glad to have you join us, everybody, here today. And today actually is going to be the first day where we award 1 hour of free MCLE at the InReach website. So we're a previously recorded, usually their webinars. So we'll announce at the end how you get that, right?
And you have to wait
Gotta
till the
keep.
end and raise your hand that we know that you're here.
That would be good. That would be good. We want to make sure that you're here. We want to make sure that you get all the privileges of joining us for our hour. That has nothing to do with the fact that you automatically are eligible for 1 hour of free self-study MCLE just for listening in on today's program. But we want to give our listeners something extra special. And so one of you will be getting that extra hour. All right, Michael, let's see what we have on our agenda for today.
We
I
have
can switch my
a couple up
slide.
my a couple of them are up my neighborhood.
Yeah, you know what? I thought about that. You tend to be aware of either the lawyers or the judges in so many of the cases that we have.
And
Last,
I'm aware of the lawyers on two of these cases actually. Well, two or one. I guess it's one.
so in last month, there was a case involving a property that was a mile away from where I live. So here we are. Here's our agenda today. What's up with us? Well, first, we're going to start off. We're going to talk about Baca versus Quang, right? What happens if you accept rent after termination of a tenancy, but proceed with an unlawful detainer nonetheless? Then we got Goomerang versus Bramer on Raymond. And this is another case that stems from a commercial landlord tenant relationship, but the primary issue in the case has to do with a motion to strike under anti-SLAPP, right? An anti-strategic lawsuit against something participation, public participation, I think. But we're going to see how it's actually relevant to a commercial property transaction. Today, you see our interview is with nobody. We're just going to be talking about our cases today. So we're going to pick up a little bit of time there. Then we've got Hefese versus Guevara, which is a local, for at least where I am and where Michael is, a local, but it's a published case arising out of Los Angeles County dealing with a unlawful detainer and whether a enforcement fee is considered rent or not for purposes of completing the unlawful detainer paperwork. And then something that I thought might be relevant, we're real property practitioners, real property law really crosses over into so many other areas. And this one is crossing over into a marriage dissolution area, in re marriage of Allen. And I thought that would be an interesting case for our members to hear. And as usual, we'll tell you about what's coming up at our PLS and ways for you to get involved. Ready to go, Michael?
I'm ready.
He's got that smile. Look at that. Michael, you did something different. You're not in the dark. What did you do different today than you've done
I,
in the past?
I, I closed the blinds.
You
Can you believe
closed
that?
the blind.
So
Okay.
this is the view, which has a fake picture of. But if I close the blinds, then it just makes it brighter in this office. I don't know why.
Ah,
So,
okay.
so now
Well,
that's what I did.
I'm glad you figured it out. It's nice for us to be able to actually see you, Michael.
Sometimes you have to make it dark to turn on the light.
There you go. It's darkest before the dawn, all those kind of cliches. Well, we're glad that we could see you. And let's get started. Let's talk about Baca versus Quang, a case decided in January of this year, right? So we had a few cases. We're still looking at some cases from 2024, I think, last month. I think every case this month is a 2025 case. This one is January. What happened in this case? Well, a commercial landlord gave a 30-day notice to terminate a commercial tenancy. No problem there. The lease had typical provision, a 200% holdover rate if the tenant remained after the termination. And lo and behold, after the termination expired, what did the tenant do? The tenant submitted a check to the landlord for rent at the previous rate, right? Whatever the tenant was paying before the termination. The landlord cashed the check. The very next day, what does the landlord do? The landlord files an unlawful detainer action based upon the termination of tenancy that was provided, and they gave them more than 30 days notice. I think they gave them something like 45 days notice. Okay. So they did that the very next day. During the pendency of this unlawful detainer action, the management company sends invoices to the tenants for rent and for 3 months worth of CAM charges, common area maintenance charges. And what does the tenant do? The tenant pays. And the invoice was not for the 200% holdover rate, it was for the amount that the tenant was paying before. The tenant did pay. Some information that I found out separately, I don't think this was actually in the opinion itself, is that the tenant actually made one payment for 3 months worth of rent and did it electronically. Well, all of those amounts for the 3 months rent, for the CAM charges, were never refunded by the landlord or the management company. And the tenant was saying, as further proof that they thought my tenancy was continuing, we also received a demand for proof of insurance. All right, so move on. What happens? The landlord is pursuing the unlawful detainer action. The trial court says, well, we have a civil code provision, 1945, that says there's a presumption that the lease continues post-termination when there's been an acceptance of rent by the landlord, right? Well, excuse me, the trial court said that presumption did not apply in this case. That presumption did not apply because there was other factors that said we are going to override that presumption. And the trial court awarded the landlord possession plus $51,000 in attorney's fees plus $24,000 in holdover damages. And what happened, I said the wrong thing here, it was not the tenant appealing. Yes, it was the tenant appealing because the landlord was ordered possession. What happened in the appellate court? The appellate court reversed the trial court decision. Now, it turns out there is a petition for review pending with the California Supreme Court, but it has not yet been decided on. The last I looked at, which was a couple of days ago. Just so you are aware that there is the possibility that this case might go on further. So let's take a look at Civil Code 1945. What does it say? If a lessee of real property remains in possession after the expiration of the hiring and the lessor accepts rent, exactly what happened here, the parties are presumed to have renewed the hiring on the same terms and for the same time, not exceeding 1 month. So basically what happens is by accepting the rent, what you have is the parties have now entered into a month-to-month rental agreement. What did the appellate court go on to say? Well, they looked at the testimony. The landlord said, well, I believed I can continue to accept rent. It has nothing to do with my ability to continue with my unlawful detainer action. And the landlord also argued, well, there's a no waiver clause, and the tenant did not pay 200% as the holdover clause says, and therefore, this is not right for that reason as well. And the court said, well, wait a minute, we're looking at this, we're looking at your holdover clause. We've looked at other cases where there was a holdover clause and it was clear that the landlord was accepting rent, okay, as partial payment for the holdover. But that's not what you did in this case, because in your unlawful detainer, you asked for the full amount of the rent. So clearly you were not using what was paid as a credit towards something else. And then the court said, you know what? You never expressed to the tenant that the continuation of the unlawful detainer was your statement that you were not accepting, that you were rebutting the presumption that there was a continuation of the lease by accepting the rent. And I think when the court says that, the court is also saying, when you did the unlawful detainer, you had already accepted the rent. So the presumption was already in place. You can't subsequently say, I am rebutting the presumption, because the presumption occurred on the date you accepted the rent. And you filed your unlawful detainer after that, and it's too late to rebut the presumption. Michael, what do you think about this case? Right? Wrong? A mix? Would you do something different?
This case was 1 billion% decided correctly. It's just kind of like a litany, like a list of things wrong by the landlord and the trial court. Okay, like I'm dumbfounded that the trial court ruled in favor of the landlord in this case. But let's just kind of go through some things, and I'll give you guys some pointers of how to avoid certain issues. First, this was based upon a 30-day notice to quit. Okay, so not about rent, not about a default. This is one of the points that was made in the decision. It was a 30-day notice to quit. It's kind of I mean, I'm surprised it's even published, but whenever a landlord accepts rent, with one limited exception, they're going to be reinstating the tenancy or creating a waiver. So here's the first hint, although it doesn't directly apply to this case. This is a 30-day notice. So if you do a 30-day notice and you're saying essentially that your tenancy ends in 30 days, then on the 31st day after that, the tenant tenders a check, even if it's a partial payment, you're reinstating the tenancy. End of story. That's correct. Here's my hint. A lot of eviction cases are based upon a breach. Same thing happens if it's a perform or quit notice. You've basically done a waiver. What is a waiver? A knowing acceptance of, say, money, knowing that there was a breach. Okay, it's pretty knowing when you accept, not annoying, but knowing that when you accept the rent, you're saying, oh, cool, okay, just give me your money. You're continuing with your tenancy. An exception is a fairly new statutory exception, fairly new meaning probably now 30 years ago, but that's CCP 1161.1. The Code of Civil Procedure 1161.1 is what I refer to as the estimated rent 3-day notice. That's the only notice where the landlord can serve in a commercial setting only, not in residential, that says we're making a reasonable estimate of the rent you owe as being, say, $1,000. And if partial payments of rent are paid, it's not a waiver. Okay, and the statute talks about it. There's an issue about, obviously, what if the tenant pays all of the rent? Okay, and there's also some statutory presumptions as to what is a correct amount of rent, you know. But 1161.1, the estimated rent notice, is the only one where someone can accept the rent and continue on with the case. Okay?
Michael, I have a question for you
Yeah.
because I do not litigate. So in this exception rule that you stated, does the notice itself state the rule that a partial payment will not create the new tenancy? Or is that just rule stated in the law but not in the paperwork?
So that's a pretty insightful comment. And you have to have in your 3-day notice a reference to this 3-day notice is um, governed by 1161.1. That's basically all you have to do. I do more than that. I actually have a phrase that's like acceptance of rent under this notice does not reinstate the tenancy. I kind of like put some stuff like that in there. But yeah, you have to make a reference to 1161.1. Okay.
Okay.
There's another concept of the waiver, the no waiver concept. I think there's a case that says under your general no waiver clause of your commercial lease, that's another basis, but you have to have the 1161.1. I'm also pretty sure in this bucket case they're using a car form. That's my feeling. I mean, I'm not a car form, American Industrial Real Estate Association lease by the paragraph numbering. That's my thinking. Um, but there's another case that's really kind of important on this. It's with the evictions. It's called EDC Associates versus Gutierrez. It's a 1984 case, 153 Calab 3rd, 167. That makes a reference to the general rule that a lessor's right to declare a forfeiture of a lease arising from a breach is waived when the landlord, with knowledge of the breach, accepts the rent specified in the lease. That's kind of like that other aspect to here. So this landlord is saying, oh, I didn't necessarily waive any of my rights, but it's just not going to work because you clearly can't say, I'm kicking you out and then take the rent for the period after the forfeiture, which happens on that 30th day after the 30-day notice. You just can't do that. Okay, that Civil Code 1945 is a presumption that acceptance of rent creates or renews a tenancy. That's it. I mean, that's the whole thing. Claiming after the fact, oh, they still owe me damages or something else. No, it's just not going to work. It just doesn't work like that. One of the common things that pops up also is and I'm not going to give you the answer to it because I don't know the answer, is a eviction's filed and then the tenant unilaterally deposits money into the landlord's bank account, okay? Or the landlord, say it's a rent case, accepts a check, kind of like in this case, saying, oh, the management company accepted the rent check, but I'm the landlord. I didn't really know that the management company is going to do that. But that's your ostensible agent, okay? So they shouldn't be accepting rent checks knowing that that's a waiver. The other issue is automatic payments. This is a problem. A lot of landlords want to have automatic rent payments. Well, I tell my landlord clients that you better like close out that account because if you accept that rent payment, it's a problem. Some lawyers for owners say, okay, if you accidentally accept, say, the rent check, then write a refund rent check to the tenant. But here's the problem. If, say, you do that and the tenant never cashes that rent check, what does that mean? You still accepted the rent. You cash that rent. Just by you writing a new check that the tenant holds on to, that's not going to cure the default. And that happens actually a lot. Okay. Um,
So Michael, that this case did mention that issue, right? Of the accidental acceptance of the rent. And this case did mention that there are other cases that say, okay, the presumption does not take place as long as you do what Michael just suggested, that the accidental collection is refunded. But this case does not go into the issue that Michael raised, which is what if the tenant says, no, I'm not going to cash. I'm not going to cash the money that you sent back to me. I intend to stay in place, right? Listen, to me, you've got another issue there, which is Worst comes to worst, if you're in that position, you give another 30 days notice, right? You don't wait a half a year to litigate, which is a risky thing to do. And in this case, wound up costing them, at least, they did not get to what they had $51,000 in attorney's fees. They had holdover damages that they're not going to be able to collect as a result of the appellate court opinion, right? So for much later on, once you realize a mistake, correct your mistake or take a secondary action to prevent that mistake from getting any worse.
Yeah, this happens all the time. I get cases that come in and I see that the landlord made a mistake. My first questions are, have you accepted any rent payments? Um, I check things about corporate standing with clients too. I do all these preliminary things and I tell them just do the notice again because I'm continually dumbfounded how many people that I think are sophisticated landlords are like, oh, kind of like this. Oh, they just paid me the CAM charges. You know, the CAM charges is only like $150 a month. I go, okay, but it's $150. And guess what? It's probably deemed additional rent under your lease. Plus, guess what? How do you apply it? Now, applying payments is another issue kind of related to another case we have today. But you got to ask these questions. I don't know why people assume I don't know, they bring in a case and let the secretary file it. This is like, this case is like amateurish all over for the landlord and the trial court. I don't get this case, but the decision is correct.
And I'm going to just make one other comment on an issue that you raised, Michael, which is if you're the owner, you have a management company, and for some reason you are terminating a tenancy, it's incumbent upon you to let the management company know, right? So that the management company does not inadvertently collect rent, so that the management company does not inadvertently send out notices to the holdover tenant saying, please give me your proof of insurance, please pay the current CAM charges, please pay the rent for the current period of time that you're in possession. Yes. I mean, Michael, you said ostensible agency. I think there's actual agency in that situation, not just ostensible agency.
Well, and what you just described happens all the time. Okay, so first, the management company is the one that I'm thinking is issuing notices like invoices and collecting the rent and depositing the rent. Usually the landlord is kind of left out of it. But these management companies, I've had this multiple times, they keep issuing um, invoices each month. So you might be successful representing a tenant saying, yeah, I got this 3-day notice and maybe we could say I tried to pay the rent, they didn't take it, but then the next month they sent me another invoice. Is that a withdrawal of the 3-day notice or a waiver? And then they say, I went and here's my proof. I went to try to pay now 2 months of rent and I have a check. And they said, no, you're under eviction. Then it's like, but you sent me now 3 months of invoices. That's a waiver. And you might get a judge to go along with that.
Not the judge in this case, but
Oh,
maybe another judge, yes.
another judge. Maybe
Another judge, yeah.
in the LA case that we have a discussion about, or I
Right.
know the people.
Yeah.
Yeah.
Yep, lot of risk, lot of risk. So thank you, Michael. Good to have your insight. Let's move on to Goomerang versus Bramer and Raymond. And here we have a case, and we know explicitly in this case that because I saw in the opinion that we are dealing with the AIR CRE standard multi-tenant shopping center lease. And what happened? The landlord and tenant entered into, lessor and tenant entered into an agreement. The premises was going to be used as an ice cream parlor. Took 8 months for the tenant to prepare the property properly. Finally got in, took possession. 8 months after that, there was a fire. It spread through the building, of course, damaged the tenant's property as well. The fire started elsewhere. The fire did not start in the tenant's premises. There are provisions in the lease agreement, provisions that said what? Landlord's responsible for the fire sprinkler system, for the interior walls in good condition. Tenant, you have to keep a liability policy. There's a tenant there's an indemnity clause where the tenant agrees to indemnify the landlord. There's exceptions, but only for landlord's gross negligence or willful misconduct, right? And another clause, the tenant's sole recourse in the event of the fire was to make a claim against their insurance company. Well, this tenant was not happy. It took them 8 months to get into the possession. After a mere 8 months in there, they lose their premises because of the fire. So the tenant sues the landlord. The landlord files a cross complaint for indemnity. I don't think we're going to do a whole indemnity class here today. I thought indemnity was for some third party claim, not a direct claim between the two parties, but I'm not going to get into that because I don't know enough about that. But it doesn't matter. There was the claim based on the language in the lease. There was a cross complaint for indemnity. The tenant says, well, wait a minute. What you are doing, landlord, is you are filing this cross complaint against me because I had the nerve to file a lawsuit against you. So that's a strategic lawsuit against public participation. The tenant files a motion to strike the cross complaint. Okay, what does the trial court say? The trial court says, well, we're going to grant the motion on some of the causes of action, but we're going to deny the motion to strike on other causes of action. And the reason we're going to deny tenants your motion to strike is because we think the landlord's likely to prevail in the merits. Tenant says, well, I don't like the fact that some of my motion to strike was denied, so the tenant appeals that. The appellate court looks at Code of Civil Procedure 425.16, and I gave a little bit of the history for that in our appellate court decision section, and said basically you have to do a two-step analysis. And step one is you look to see, is the complaint related to a protected activity, to free speech, to participating in the judicial process? Or is the complaint of, in this case, cross complaint, related to something else? If it is related to free speech, only then do we reach the second part of the analysis and look at whether the party who brought that is likely to prevail in the merits nonetheless. And the appellate court said, well, we look here, we say, guess what? Tenant, you were not even able to go beyond the first step in the analysis. The cross complaint was not designed to intimidate you from speaking freely or from participating in the judicial process. The cross complaint was related to the term of your lease that said there is going to be indemnification. That was the whole point of the cross complaint. It was not designed to prevent you from speaking out. It was designed for the landlord to attempt to achieve their rights of indemnification under the commercial lease. Since you can't even get past the first part of the analysis, guess what? Your motion to strike is going to be denied, even on those other causes of action. Michael, does that seem about right to you? It seemed about right to me.
It seems right. The issue about what is a protected activity as opposed to contractual rights, that's a difference. So yeah, I get that one in this case. That's correct.
And I'm thinking this is not an uncommon situation, right? Where there's a indemnity clause, whether it's in a lease or whether it's in another agreement, a purchase agreement or something else, and the party who wants indemnifications to say, I contracted for that right, and I'm going to pursue that if litigation has been started against me.
Yeah, as opposed to that right of petition or free speech. And
Right.
the right of petition is filing the lawsuit. There's something that came up in here which I see a lot, and I kind of do it myself. So in commercial cases, there's always like a insurance requirement. I'm not always, but usually there's an insurance requirement. Yeah,
Mhm.
one of the things I do tend to do when I represent a landlord is I tell the tenant, "Oh, wonderful, you're suing me for some sort of a problem here. As long as it's not like just pure breach of contract, okay, as long as it's something kind of like this that they're saying there's a failure to maintain or breach of the warranty of habitability or something, I make a demand for indemnification under the tenant insurance policy. Most landlords have their own insurance policy. I mean, a smart landlord has their own policy because tenants may not pay for the policy that they name you as an additional insured. And sometimes landlords don't follow up to make sure that they're still a named additional insured. But I will tender it and try to get the tenant's policy to cover the lawsuit where the tenant's suing the landlord. And that's what they did here.
So Michael, you raised an issue that I'll just kind of go a little bit further, really unrelated to this case. And you're talking about the lease requiring a landlord to be named as an additional insured under the tenant's policy. And I know in my experience with CAR, we found that this is very difficult in in the residential context, in particularly for residential property managers. So even if the lease said that the landlord or the property manager was going to be named as additional insured, at least in the residential context, it was almost impossible to get that type of policy. And what many insurers were doing is they would instead issue something where the landlord or the property manager would be named as an additional interest holder as opposed to an additional insured. And so just for those of you, and I don't know how much this would apply in the commercial context, but for those of you who deal in the residential context, there's a huge difference between being named as an additional insured, which means you have protection under the policy, and being named as an additional interest holder. An additional interest holder will be notified if the insurance lapses or if the insurance is terminated. So that if you wanted to make sure that your tenant was still covered, right? So that you would have, there'd be somebody else to look to for an injured party or for damage, there'd be somebody else to look to, which would be the tenant's insurance policy. You know whether that policy is still in effect if you are an additional interest holder. But there's a big difference between that and being protected by the insurer, which is only available for somebody who's named as an additional insured. So just thought I'd bring up that extra little point.
Yeah, I think the genesis of that is along the lines of in a residential case, residential apartment, the tenant policy, it's very limited and they only want to insure the tenant's personal property. And it's something along the lines of the insurer is only going to insure the owner of the property that's been damaged, and the tenant's interest is what's inside the unit, like personal property, as opposed to the ceiling or if there's a fire or flood or something like that. I think it's something along those lines.
Well, it could be. I mean, you can get renter's insurance, which is not going to cover any of the structure at all. It's only going to cover personal property.
Yeah.
But even if the tenant is able to get a liability policy, which is fine, that liability policy may not protect the landlord if the landlord is only named as an additional interest holder. And so I'm just pointing that out. It may be something that you may want to look to or make sure your clients look to make sure to find out if they are getting the type of protection that they thought they were getting. That's all. Just a little bit of extra information there.
And today, a multi-unit apartment building owner to get insurance, I'm getting a lot of calls. This is really tough. I don't know all, but a lot of the major insurers are just no longer insuring buildings, like apartment buildings. This is going to lead to another big problem. Um, there are a lot of recent cases in the last few years where tenants are suing the landlords for what I think are ridiculous or no claims, and the lawyers are taking these cases, filing sometimes I think 100 a month, and um, trying to, I just say it, extort damages out of the landlord, thinking there's insurance, but there is going to be less and less insurance, or people are going to be, um, maybe they're given a couple months notice to get a new policy, but they can't get a new policy because their building doesn't qualify anymore. It's an old building or something. Then there's going to be lawsuits filed. There's no insurance. The landlord's trying to get insurance, doesn't get it. It's just going to be a big mess. This insurance thing is a big problem.
Yeah, the insurance availability is widespread throughout California for both homeowners and commercial property owners and for homeowner associations, right? If you're in a HOA, the HOA itself needs insurance, and they're having problems getting what I'll say is affordable insurance as well, which means in that situation, the only way for the HOA to meet those premiums is to increase dues of the homeowners that live in the complex. So a
Or these
big issue in California.
these landlords now go from an insurance policy that maybe they're paying five or $8,000 a year for, and now they're gonna get $35,000 a year or more. This is like a big problem. Everything's inflating.
And if what you have is an apartment building and you're in a rent control jurisdiction or you're covered by the Tenant Protection Act of 2020, you're not going to be able to increase rent to cover your increased cost, which is another problem as well. All right, Michael, we are really going astray here. So let's go on to our next case. FSA versus Guevara. And this is one where you probably know everybody in this case, right? And so
That's
here we have a residential
that's
landlord
right.
in LA County filed an unlawful detainer complaint against the tenant, found unlawful detainer. The complaint stated the rent was $15.50 a month, but the 3-day notice to pay rent or quit, what does it say? Or 3-day notice to pay rent, said, yeah, pay rent or quit, said $15.54 and 44 cents, right? So off by $4.44. Okay. Well, in Los Angeles, the what is it called? The systematic code enforcement program fee, which basically what you're paying to have somebody come out and tell you everything that you've got to fix in your property, everything that's wrong with your property. I know when I was a landlord and I owned property in northern LA County and I was having trouble with my tenant, what do? They decided to break things in my unit and then called for an inspection, to have me fix everything that they just broke because we were having some differences. In any event, I'm sure that doesn't happen all the time. I'm sure there's legitimate reasons for the systematic code enforcement program fee, to make sure that properties are habitable, right? So there's legitimate reasons for that.
Or to provide
But
employment for inspectors.
that, well, hey, it's good if you can get it, I say. Why not? Why not? So prior to the trial, the tenant filed for a judgment on the pleadings, saying, guess what? Fatally defective because the 3-day notice demanded more rent than was due. All right. So the city code allows that fee to be passed on to a tenant. But as the trial court said, well, but that fee is not rent. That fee is not additional rent. Mike was talking in the first case that there may be other things like CAM, common area maintenance, which might be deemed to be additional rent. But under the LA code, guess what? That SEP fee is not considered rent. You can pass it through, but it's not considered rent. If it's not considered rent, that means the 3-day notice overstated the amount of rent that was due. Therefore, the unlawful detainer was invalid. This case went up to the appellate division of the Superior Court. The appellate division of the Superior Court affirmed. I always like to remind everybody, decisions of an appellate division of a Superior Court, they're not binding throughout the state like an appellate district court is binding for all lower courts throughout the state. It is really only binding on trial courts within that jurisdiction. So within LA County, but LA County is the biggest county in the state of California, right? So it's good to be aware of what's going on in Los Angeles County. A 3-day notice has to state the exact sum due. If the exact amount is not stated, guess what? You've got to start all over. I'm sure Michael has seen that in other cases as well. And I have a little reminder down there at the bottom of our screen that that strict compliance rule does not apply the other way around, at least not in LA County, because we had a case from a few years ago, excuse me, Bawa versus Terhune. And what did that case say? That case said that, well, a trivial breach by the tenant, okay, is insufficient to support a unlawful detainer action. And that was really kind of a problematic case because let's say you're charging the tenant $2,000 a month rent. And tenant says, you know what, I only feel like paying $1,900 a month. Is that, I don't know, is that a trivial breach? Or if the tenant says, I'm only going to pay $19.90 a month, is that a trivial breach? So who's going to determine how much it is, right? So there's no leeway for the landlord in establishing the amount of rent that's due in the 3-day notice, but there's certainly leeway the other way. Michael, your turn.
Okay, so this case is huge, okay, for Los Angeles landlords. Okay, this is something that's been, this concept about the skip fee or SCEP, whatever you want to call it, this has been a problem for a while. And yeah, I know the landlord's lawyer, and I can completely understand how he's thinking. But even the trial court had to take this one under submission and kind of think about it. Um, Do I think it's right or wrong as an initial thought? Yeah, I think those SCEP fees are a condition of occupancy because they're allowed to be passed through. Okay. But this is really parsing out these statutes. So what do I think? Well, this is a real windfall for the tenants, but I'm also going to tell you how I've been trying to handle these things to try to fix it. Um, I know I'm fixing it before we're doing the analysis, but the analysis was essentially what is considered rent. The rent control ordinance has a provision kind of defining what is rent. I can see how that should be included as what is rent, but I can also see how these fees have nothing to do with like the contract rates for the rent or reimbursement for like electricity or something that's like directly tied to the rent. Okay. But I think that, and then they talk about the statutory construction and what did the LA City Council intend, how they parsed out the 151, code sections and coming up with it. I don't know. They're just being a little bit pro tenant. Oh, that Bawa case, by the way, that's always the case over like a penny. Okay, that's why it was like de minimis. And the landlord wasn't accepting the rent. That was like another crazy case. But I'm gonna tell you how to fix this. So
Okay.
I'm looking at part of the opinion, sort of the beginning with the facts. And the landlord, when they did the 3D notice, it looks like he wrote out the total of sum due is 3,132.64 calculated as follows. Okay, I think that is the problem. So if you look at the CCP 1161 paragraph 2, that's about non-paying rent notices. It only states that you have to state the precise amount of rent then due, meaning some landlords and some of these forms floating around for years say maybe monthly rent is $1,000 a month, due period from like January to another date. That's where you get problems. Okay, the law only requires the state the precise amount of rent then due. So if $1,000 is due, right, $1,000. At the bottom of the nose, it has a date. You date it, and then you have the landlord sign it, and that's the date due as of that date. That's all that's required. When you break it up and you say, calculated as follows, $23.76 for August 1 through the end of August, or $1,500 for September 1 through the end of September, $4.02 for your SCEP fee. This is where you have a problem. And there's a lot of problems that come up. One, for a um, judgment on the pleadings, and tenant lawyers are filing these judgments on the pleadings, the judge might look at this and say, well, this SCEP fee is not rent. We're going to go with that. Summary judgment motion, they might do the same thing, although I think they have to go a little bit further beyond the pleadings on that. But if you just state $1,000 is due, then you're good. Here's the other problem that comes up commonly. If you put a date reference and there's more than 1 month of rent, sometimes tenants on their checks, let's just say the tenant has to pay for 4 months, January through April, and the landlord on April 3rd serves a 3-day notice, but it's saying this is rent from January through April. What happens if the tenant happened to tender a check and wrote on the memo field of the check rent for February? Okay. What if even before the 3-day notice, the landlord, the tenant wrote a specific date that the rent should be applied? This is going to mess it up because a judge might say, well, in that period of time that the rent was paid, maybe there was a accrued balance, but he paid rent during that period. It just messes things up. So just state the precise amount of rent, then due.
So Michael, I've got a question for you.
Mhm.
If one follows that advice, are you not really just postponing a decision that could have been made prior to trial to a motion that could be made at trial, which is, isn't there going to have to be some evidence as to how you came to your $1,000 figure? And you're going
Yeah,
to have to break it down at some point in time?
yeah. You're gonna have to break it down at some point in time, but let me tell you like how landlord attorneys think. Not me. I'm the opposite. I want to stay out of court. I want perfection. I don't want to do things twice. Okay. Landlord mill attorneys, which is kind of like what we're talking about here. The paperwork is generally processed by the secretaries and I think very rarely looked at by a lawyer who thinks about it. Why do they do that? Because most of the time you find a way to settle a case. Okay. So you show up at court, landlord attorneys want to settle the cases at court, they make their fee, and it's easier to deal with things. Decisions can be made on the spot. So even if the case is wrong, like the 3D notice is defective, kind of like the odds are, and I'm going to put the odds at much higher than 50%. Once you show up in court, the tenant knows they didn't pay the rent. There might be some problem, and you can like get a divorce happening where the tenants and the landlords are able to make an agreement to have a parting of the ways. Okay. So that kind of like cures the defect because no one cares about those defects. They care about the bigger picture. That's kind of how most mill attorneys think. So that's why this happens. I'm not saying it's correct. I don't do that because I don't want a landlord complaining to me, why didn't you ask me this question or catch this problem? Because I'm not a mill attorney. Okay. I don't do that. So that's why this happens. Um, but yeah, at the end of the day, they're gonna lose. And this case is a godsend for Los Angeles tenant defense lawyers.
And has it been for someone who practices in Los Angeles, has this been a open question throughout LA as to whether one can claim SCEP fees as rent, or is this an unusual situation?
It's not unusual. This has been coming up for years, but
Okay,
this is the
all right.
only case I've seen like this.
So the court actually, whether you agree with the decision or not, is creating some clarity in Los Angeles County for dealing with this issue.
Yeah. And like I said, I
Oh,
think that rent control ordinance, this fee is a mandatory fee, and it's clearly in connection with the use or occupancy of the rental unit because, part of this fee is allowed to be passed through. Okay. But I also understand the issue about the suggestion to do a perform or quit notice. Okay, so that's that. So perform and quit notices historically, I have a conversation with my landlord clients. I go, your rent is $1,000 a month. Why are you asking for, $1,025? They go, oh, that's a late fee. So I say, no, 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 no. Let's redo it. New notice. You want the late fee? Absolutely fine. We do a perform or quit notice and we say that that $25 is the late fee. If there's this SCEP fee, then we'll put that in there as well. You have a different problem, which is you have two notices, you serve it. What if the tenant performs under one notice but not the other? I think it's okay. You just go under the one they didn't perform. If they breach both of them, now you got kind of a little technical issue about having like two legal theories for the breach. And then one legal theory, is it protected, say if there's a retaliatory eviction defense, like on the perform or quit notice, because a ret notice has no retaliation as a defense. It gets really complicated. That's why people have to really use a lawyer that, even if there's no answer, they warn the landlord of the potential problems, and the landlord can make a decision what they want to do. And I usually say, forget the late fees. Okay. I don't want to deal with retaliation or anything else. I want to keep it really simple because the odds are you'll win and it's done. And if you work it out with the tenant, wonderful. But those are these issues that have to be explained, and I think it's not explained to the clients as they should be.
Okay, and Michael, I just thank you. We're going to move on. This is great. You know, um, I kind of like your situation, which is when I say in the one situation, are you just kicking the can down the road? And maybe you are kicking the can down the road, but if you never get to the can because you settle it first, no harm, no foul, as they say in basketball. Okay, before I'm going to switch the slide, you can start reading about the next case, but I see there was a Q&A. There was a question here. And so let's look at that question. And it's going back a bit, and I'm sorry I did not look at the Q&A earlier, Lisa. If landlord is an additional interest holder in residential renters insurance, is that why landlords are refusing to help tenants to remediate smoke damage in rented units affected by the LA fires? So that's a good question. I don't think they are related. I think the landlord probably has their own policy protecting them, from fire, a policy, a property insurance policy, protecting them, the property from fire damage. There are questions. We've had a couple of cases that we've seen this year that addresses whether the insurer has an obligation to cure smoke damage. And we've got one strong case, California case, and then we have a federal district case in California that came out with the opposite conclusion. But the California case said, well, you know what? If the smoke, the ash can just be basically wiped up with a wet cloth, there's no damage there, right? And Michael remembers this case. We had a tenant who was really, I think, overreaching, or the property owner who was overreaching in what they were demanding from their insurer, who was actually really meeting them more than halfway, wound up going to court, and the court said, that's not damage. But there are cases that recognize there can be long-term effects from smoke, right? So I think landlords are saying to themselves, well, if my insurer is not going to pay me because my insurer is saying this is not a physical alteration of the structure, then why should I have to remediate that problem for the tenant? I don't really think it's related to being an additional insured or additional interest holder. I think it's the landlord saying, I need to be compensated because I don't have the ability to do this on my own, or I just don't want to spend the money to do that on my own. Here's a problem that residential landlords have.
But Neil, what the
Which
question
is
is,
weird.
but does
Yeah,
the landlord have an obligation to clear out that smoke that might be making it uninhabitable?
that's exactly what I was getting into next, Michael, which is exactly it. So we've got an attorney general opinion who opines that this could be a habitability issue. Now, that's just an opinion. That's not binding precedent. So that's why you've got this problem here, right? So you talked about discussing with landlords what their options are. And when it comes to this issue, if you have a residential landlord, there has been smoke that inundated the property. The tenant is claiming you need to have this professionally remediated. The, sure, a landlord would like to say, hire a cleaning crew, get a mop and clean it up, and we're through, right? But the tenant's saying, no, 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 there's more here. My health is in danger right now because of this. And basically, anybody could get an environmental hygienist to come up with the worst possible claims, right? So, Michael, that goes to your issue. The
Yeah.
landlord's attorney is going to have a discussion with the landlord saying, all right, you're going to have to make a judgment here, right? Do you spend some money now to try to resolve the issue? Do you spend no money and hope that the tenant goes away, right? Or do you spend a lot of money to maybe completely remediate, and it's a judgment call.
That also means that those wise people that draft form leases in California need to think about making the leases even longer with another sentence or so about smoke damage.
If there was some clarity, I think those people who do draft those kind of forms would love to be able to write something that we know would be able to be enforceable. So thank you for that suggestion, Michael. All right, real quick, let's do in re marriage of Allen. We're already at 12:56. We don't have time for in re marriage of Allen, so we'll get to that next. We'll get to that next one. Since we're so late, because we've had some really good discussions, Michael. Thank you. Real quickly, hey, you know what I have here? You want to build your career? You want to go up the career ladder? Write an article for one of our real property publications, a long article for our journal, a short article for our monthly e-news. Matter of fact, I just wrote one last week about a case that was a few months old that I've been thinking about, and that we actually discussed here on What's Up With Us. So we got some really good articles coming out in our journal. But if you have something short, you got a couple of paragraphs, one page, you want to write about something, get it out there, pad your resume a little bit, send it out to your clients. I've been published in the California Lawyer Association Real Property E-News. Send it out to all your clients, let them know how wonderful you are. You could do something like that and help your real property section at the same time. What's coming up? A webinar on buying Italian properties. Sounds very interesting. May 15th, right after our May What's Up With Us. So you can join us for an hour and then learn about buying properties in Italy.
We should
next
invite
month.
George Clooney. We need George Clooney as our guest.
Well,
because he owns, his famous chateau in Italy, right?
to whoever's
George
putting that
Clooney.
on.
Yeah.
You know what? The last bullet point here under upcoming events, and I'm about to lose my connection, but the real property section is accepting applications to join our section as an executive committee member. The deadline is tomorrow. So you want to join us? Brooke, if you could put that quickly into the chat, the link. So
Tish
anybody
did.
who's interested, they've got one day. They can join us. They could become a executive committee member, and they could be telling us decisions saying, Neil and Michael, I think you should be talking about this or talking about that, and not spending your time on all this other stuff.
And
And
Neil, there's quite an
lastly,
important thing to talk about. The
yep,
most
go ahead,
important
Michael,
thing.
quick.
Okay, we have a winner. Our winner for today's free CLE is Charles Reibel. If he's there, try to click on the chat, and then you've won a free CLE from the library. So Charles,
So Charles, you will be getting a link from Brooke. It's not going to go out until Monday. It's going to give you a link to the InReach website that has all the education. So find the real property section, find a course that you want to take, and guess what? You're going to be able to take that 1 hour educational course and it's on us, on me and Michael and the CLA real property section. You don't have to pay for it. Thank you for joining us. Sorry we didn't get to our last case, in re marriage of somebody. We'll talk about that next month. Michael, closing words before we go.
Okay, well, so we gave everybody another reason to join in each month for our stimulating discussion, and we have some more fun cases for next month, including we'll try to give away another free, CLE program.
And I see, thank you, Brooke, for putting the links in the chat for the webinar, for the executive committee applications, and wonderful, Charles Reibel, you are our first winner, and we hope there will be many more of you to come. See you all next month. Bye for now.
Thank you. Bye.